This is SkyDog 2016 number, whatever it is. So my name is Tyler Pitchford. My quick background: I was an appellate attorney, not one of those like weird types of law like health law or anything. I did appellate law. I fought tobacco industries for a number of years. I worked at the Florida Supreme Court and a bunch of other courts. Technical wise, I have a software degree. I was the co-founder of the Azur's BitTorrent client, so you may have used that. It's now called Vooz. It was licensed under the GPL v2 back then. We had some struggles with it later on, which I'm not supposed to discuss, so we'll skip that. I was a chief technical officer at a number of companies at various points in my life and general twiddler of bits. Had a kid, dropped out of law, started going back to programming. This is what I want to cover, though. This is the more important part. So I'm a huge open source advocate. We'll start with that to begin with. But what we're going to cover is why does this stuff matter really quick. Hopefully you all have some affinity for open source, I hope. Then we're going to go into some copyright, copyleft, cover some areas you may or may not know. Especially, I think some of the intricacies of the GPL v2. A lot of people who use it don't even realize some of the requirements, which I always find interesting. So we'll cover some case law because I had a request yesterday for that. We can zoom through that very quickly if no one cares. There's actually not a lot of case law in open source software, very, very thin in the appellate world. And then what I really, really, really want to spend more time on is the last part on some thought experiments. One advantage that SkyDogCon and some other smaller cons like this is that you can actually interact with your audience. And I'm really hoping to get some feedback. And we'll cover some exploits you can do with open source licensing and trolling. And then what I really want to cover is the mafia style open source and see what we can come up with there. So if anybody's seen me speak before, you know that. Feel free to just throw out questions at any point. I'd rather have a dialogue than just diatribe to you. So let's rock. What we will not cover, let's start on this, not how to get around open source licenses. I assume everybody knows how to do that if they want to. If not, you can always hire an attorney, just not me. And I usually have a legal disclaimer in here, but since I don't practice day in and day out anymore, I can skip it, I think. But I am an attorney. I'm just not your attorney. So don't rely on my legal advice here. Consult your own attorneys because I'm not licensed in Tennessee.
He's my attorney in Florida.
Yeah, that's true. In Pensacola, every time he drops his trowels, I get the call. No, I'm from Florida. I'm from Tampa. Grew up in West Palm Beach and then was an attorney in Tampa, Florida. Oh, do you? All right, yeah. I spent a good bit of time up there when I worked at the Florida Supreme Court. So. Copyright versus copyleft. I assume everybody knows the difference? No, okay. So copyright, you get the exclusive legal right to something. And you can read the rest of this if you want to. Copyrights are extremely intricate, interesting beasts. They've been exploited in a number of ways, but they're extremely powerful. And my favorite way they've been turned around is to copyleft. So copyleft, the entire concept of open source in the GPL, for example, is based off copyright. Without the copyright, we couldn't have this concept of binding you to in a license or an agreement to comply with these extra rules, which we now call copyleft. So one funny thing about the GPL is it's actually copyrighted, right? So the FSF, the Free Source Foundation, has a copyright on the GPL, which is then distributed out with your software, and now you've agreed to this license like an EULA on the agreements. And we're going to cover some of the case law on conditions versus covenants, which is extremely intrinsic and deep entrenched law that no one really gives two flying you-knows about unless you're in an appellate battle for copyrights, which is fun or not. But so copyleft is essentially largely open source software. You can read a more formal definition there if you want. And that footnote on the bottom about conditions is specifically in regards to this whole conditions versus covenants. Like I said, we'll cover it in a little bit, but it comes down to if you write open source software. Anybody here write open source? Do you guys use free source or open source licenses? Open. Anyone on free source license? Wow. So most people aren't on JavaScript then. I find JavaScript is always like BSD or MIT. It's very interesting. So the dividing line here is copyleft is usually considered the dividing line between open source and free source licenses. So there's free source, aka the BSD and MIT licenses, which is, pretty much do whatever you want, which we'll cover. There's not a lot to it because it's pretty much free for all, other than some of the older licenses did have things like attribution clauses and whatnot. So in property law, we use this concept of a bundle of sticks, and intellectual property law uses the exact same concept. You have a bundle of rights, or the analogy is always this bundle of sticks. And I can give you one of those sticks, but I don't have to give you all of them. So for example, books is a common copyright example. I've written a book, and you would like to produce a copy of it in Spain and translate it to Spanish. So I can give you the right to translate it, and then I can give you the right to distribute it. Or I could just give you the right to translate it, maybe give you some royalties, but not the right to distribute it. So you do the work of translation, and then I retain the right to distribute it, and then I can distribute it. But I don't have to give you everything. I can give you a little piece, or I can give you a whole piece. Copyleft is essentially bundling some of those conditions, some of those rights. So for example, with the GPL v2, we say you can redistribute this. However, you have the right to use my copyright. I give you the right to redistribute, which is one of these rights in that bundle. But you must comply with these other rules, which, typically in the open source world, it's roughly defined as, you have to allow free redistribution. There's a lot of extra things you have to do with the GPL v2, but most people don't actually ever do that, which is kind of funny. So this is the dividing line, and keep that in mind. You got copyleft, copyright, free source. So open source, copyright, free source, or closed source, open source, free source. And that comes into play on various things you're doing. Now, in intellectual property, we can cover this too really quickly. Does anybody know the different forms of intellectual properties? Anyone? Oh man, you guys really should learn those before you distribute any software. Who knows patents? Who hates patents? A lot of people, I'm sure. Yeah, patents. Software patents are based on this whole concept of business process, which is complete and utter shit. Yeah, it's, like one click to buy. Woo! I made a drop-down menu. Who gives a fuck? Like, I clearly don't like software patents. I think they're complete and utter crap. And then you got, physical patents, which I get more of a concept of. Like, I've invented this device. Like, I put a lot of R&D into it. I need to recoup my costs. I get 21 years to now exploit it, and after that, everybody can make it because it's better for society. Copyrights, on the other hand, another form of intellectual property that we're mostly going to talk about, formerly you had to renew your licenses in a limited duration. It's still a limited duration, kind of. Essentially it can run up to over 100 years, which is, 95 years being roughly what it is until death and then beyond, which is just kind of fucking nutty. So Mickey Mouse was why it was extended. I'm sure everybody is familiar with that whole, the Mickey Mouse amendments where copyright was extended specifically by Disney Disney lobbied Congress to extend the copyright duration, and now we've got these ridiculously long copyrights where nothing will actually come into the public domain, I think until 2032 or something ridiculous like that, which I'm completely opposed to. At one point I was going to troll the whole Superman world because there was an issue where Superman fell out of copyright. Someone forgot to renew it on one of the licensed properties. And the only reason it's actually not in the public domain now is due to you can use a trademark to protect a copyright in a completely not proper fashion that's been sanctioned by California. Thank you, California. But that whole quagmire, we just went into another trademarks, another form of intellectual property. And then you've got trade secrets, which are technically defined in the Copyright Acts, but it's essentially you just don't tell anybody what the fuck you're doing. And if they do find out, you can try to quash it with injunctions. So if somebody finds the Coke recipe, the most recent one was the KFC recipe got released. Like, oh shit, it's 11 herbs and spices. Which ones though? Which ones? So the guy found the original recipe, like in his, I guess Colonel Sanders was his uncle or something, and he like found it in a photo book, and he was like, hey, here you go, journalist, print this. And KFC's like been all over people about it, but they couldn't do anything in that case because he had an original source. It wasn't from them, it was an outside, so it's not longer a trade secret. So all kinds of shit that attorneys come up with. So these are some of the licenses. Has anyone dealt with the CDDL? I know you've dealt with the MPL because you were at Mozilla, if I remember correctly. MPL, they went kind of nuts, no offense, on the whole patent grants thing. Drives me absolutely batty.
Not a lawyer.
Yeah, no one should be. But you got the artistic license. Anyone seen that?
Yeah,
Pale. Yeah, so one interesting thing about the artistic license is there's actually more case law on the artistic license than the GPL in the US. Yeah, like the more famous case deals with actually the artistic license, not the GPL. So you got the GPL v3, which I absolutely hate. I don't know if anybody uses it. I could tell you why not to, like my personal preferences on it. I hate what they did with it. For some reason, the open source world got this, specifically certain sects of it, got this concept of we need to force certain things down people's throats. And the GPL v3 was kind of the embodiment of it. But what they did is weaken the GPL v2, which I completely disagree with. So there's a clause in the GPL v3 versus the GPL v2 that the GPL v2 can be construed, and it's never been legally battled enough to have a definitive decision. But the FSF's argument is that under the GPL v2, if you violate one of the tenets of the GPL, if you misuse the license, you lose that license in perpetuity. Like your software is no longer sanctioned under the GPL2. You have no right to redistribute it. Your conditions have not been met. Your license has been revoked. In the GPL v3, it says essentially if you come back under compliance, we will give you back those rights, which essentially to me, I read that as the license to violate your copyright and hopefully not get caught for 3 years. Because once the statute of limitations runs, go fuck yourself, sue me, I don't care, I'll get it dismissed. And if you do sue me and you expend those resources and pay an attorney to write the complaint, have it served, we go to court, I just need to come back under compliance, let you have access to my source, comply with all the rules of the GPL v3, and then I get your case dismissed and you just pissed away 10 grand on an attorney to fight me. Kind of makes enforcement a little iffy, to say the least, which I just don't like that at all. LGPL, you guys know the difference?
Yes.
So
Libraries and linking.
Correct. So you can the GPL, if you bind it into the source, if you link to it, you technically, if it's in-memory linking according to the FSF, you need to release your source. LGPL says as long as you don't modify the module or the library or whatever form of static or dynamic you want to refer to, you're okay. You don't have to redistribute that. Your main piece is okay, the library. If you modify the library, you need to distribute that. There's a couple other ones, CDDL, MPL, artistic. We won't cover the details of those because they're a little more esoteric. You got free source licenses, Apache, Eclipse, BSD, MIT. I'm sure everybody's seen every one of those. They're very popular. Those essentially, as I said, that you have the right to do whatever you want with it. Just don't say that we wrote it, blah, blah, blah. Those are the main requirements. And then you've got Creative Commons, which allows people to select various rights of attribution. It's typically the normal one, and there's a whole coding system. It's more used in creative works than code, and then there's a whole another layer of licenses for hardware, which has become popular in the 3D world, the 3D printing world, which is interesting, but we won't cover that either. So here's some statistics. These are a little outdated, to be honest. The GPL v2 is still, by and large, the most popular, and that's still true today. They've been pushing the GPL v3, which I said, not a big fan of, and then it's a various mix in between. And just a random question for my own edification. How many people work in software or write some kind of software their companies do? How many people actually have a compliance or auditing program for open source? Do you have rules or do you actually have a program for control? There's plenty of software packages now. There didn't used to be, but no, more like just a program to make sure that nothing gets in your source tree.
If you bought the software, then someone is funding it.
Should be interesting. You guys profile it or?
No, I think it's just part of the SDLC. If somebody brings in the next gen lid, a whole bunch of stuff gets checked by compliance, and legal, I assume, would be part of that.
I take it you're in a bigger corp then, because most people just freewheel it.
Yeah.
So I've been part of several security or code audits, which is pretty funny when you catch things like, hey, here's some GPL stuff, did you know? And they're like, oh my God. Yeah, that's pretty bad. But we're actually going to cover that in a little bit. So as I said here, this basically, if you haven't read the license and you're putting some software in your source tree, you should read it very carefully. The penalties on copyright violations are pretty stiff, to be in all honesty. Realistically, in the software world, it's not enforced, and we'll talk about that very much. The enforcement wing of the open source, I somewhat rail against too. I don't think they're as adamant as they should be, especially on the hardware side. But so these are the conditions you'll usually see, and I just want to cover this really quickly. Include a copy of the license, include the warranty disclaimers, aka, this software provides no warranty. If it blows up your laptop, that's your problem. You can't sue the FSS for that, or whoever wrote the library. Attribution clauses, a lot of times it'll say oh, you got to say that I wrote this. And it's funny because most companies don't include those. So compliance typically is just added to your documentation or something. In most companies, I've worked at a handful of companies I can think of that actually had a policy of if there's an attribution clause, there was a section in the documentation where it went, and the other ones just whatever. They just didn't care, which can be a violation depending on what the court believes it's a condition or a covenant. So, track your code changes, which is one of the more interesting ones. Like, you have to make sure that if you modify something, you have to point out what was modified. It's kind of interesting. Copies of the source, that's probably the one that most people recognize into the GPL. And then provide the files to build the software. That, comes out of the GPL, but a lot of people don't realize you have to be able to build it. So one of the gaps in the GPL v2, for example, was, great, you can build it, but you can't run it. That was the TiVo exclusion, right? So TiVo made their own firmware that basically said if it's not signed, we won't run it. So yeah, you had the TiVo, and yeah, you can have a copy of our operating system. You just can't use it on the fucking thing because it's not signed by us. So Google's used some of that stuff. Android, for example, some of the exploits on it are pretty funny, which has been tried to be addressed in the Faro GPL. Which, if you see the AGPL, I actually like the AGPL v1. I think it's probably the most aggressive license out there. So you got these, like I said, we already covered this pretty much. They're the free source licenses. If you just want to let your code out there for the betterment of the world, or detriment, either way, go for it. There's not really a lot to talk about. It's pretty boring. These are the ones that are my personal favorite, the strong copyleft. I already talked about the GPL v2 versus v3. AGPL, like I said, I think is probably the most stringent one. It covers the gap in the website exclusion, or the website gap. So a lot of people would, SaaS became a big thing in the early 2000s, I would say. SaaS started becoming more prominent. So you take GPL software, just stick it behind a web server. Now it technically hasn't been distributed. I didn't give it to anybody. It's still within my company. So the distribution clause is what kicks in the GPL v2. I haven't distributed it, so I don't have to give you any source code. You're using my service still. It's not outside my company. I don't have to give it to you. Sony, for example, tried to use a beta exclusion, like, oh, the software's in beta. We haven't officially distributed it, so you don't have to get the source. That got them cracked down on, though. They just gave in under pressure, is my understanding. So the GPL v2, like I said, it requires that works or linked to may also be under the GPL. There's kind of a schism on that. So Linux, for example, says that, yeah, you've made a kernel driver that links in to memory when it compiles the kernel. I don't consider that to be a GPL violation. The FSF, the creators of the GPL, say that it is, and they should have to distribute it. There was a fight between two of the web frameworks, and I can't remember which one it was, about whether or not a plugin that was built was a violation of the GPL v2 if the source wasn't given. The FSF's guidance on that is that if it is linked in memory, in the same process in memory, it is considered linked under the GPL v2. Never been litigated, so who knows? Anybody wants to try it out? Cool. If you need an appellate attorney, let me know. Happy to jump in because that shit's pimp. I love watching it. Now, if you get a bad decision, we're all fucked, so thanks. It's probably my fault at that point, but whatever. I have actually brought some GPL suits. I'm one of the rare people in the world who's done it. And we'll talk about why it's rare, which I think is the more interesting part of all this. But make source code available. Plenty of loopholes that we just discussed, and third parties have a right to use, modify, and copy your software, which is pretty funny. And then I dipped into it a little bit, but some of these licenses have started adding some more esoteric clauses. So one conference we talked about some of the things you could include. For example, people have created their own licenses where they modified licenses or just came up with their own conditions. Like, I forget what it was. A guy made I can't remember if it was a vector tracking software or something. He made a vector thing, and he's like, you can't use this for military use. Like, he didn't want it to be put in missiles for guidance systems. He's like, you can use it for whatever you want, you just can't blow people up. Why not? It's his code, he can do whatever the fuck he wants. He's got a copyright, right? You want it, you gotta comply. So these are actually my favorite parts of the GPL v2. People never realize this. Does anybody know if you use the GPL v2, you actually have to, it requires that you have a physical distribution? I can email you and say, I want a CD. And you have to send me a CD. You can charge me for the production of the CD, but you have to send it to me. If you are not doing that, you have violated the GPL v2.
Is there a clause about reasonable cost for the CD?
There is. You can charge a reasonable cost, which I'm sure someone's tried to exploit, like, oh, it's hundreds of dollars. But, you could probably argue it takes me 20 minutes to produce that. My time is worth X. I think it's for the physical media, though. I don't know if it includes time. I can't remember the exact clause, but I always think this one's funny because no one does this shit. Like, everybody on GitHub, all the GPL, the v2 software, I guarantee you they do not Like if you emailed the maintainer and was like, I would like a CD of your software, they'd be like, you can go fuck yourself. Like, that's great, make one. And you're like, no, you have to give it to me. Like, but why? We'll talk about why that largely doesn't matter later on. I mean, it does if somebody's a commercial company, for example. So if you want to troll some company that you like just can't stand. So I bought this IP camera, and I emailed the manufacturer. I was like, hey, I found BusyBox in your firmware. I'd like a copy of the OS because I'm tired of hand hacking this shit. Like, it'd be better if you just gave it to me. And the guy's like, I don't have that. And I'm like, what do you mean you don't have that? Like, you're selling a camera with BusyBox. Like, you got to have this software. He's like, oh, I'm just downstream. I'm like, well, copyrights run downstream. Like, you're distributing this. You have to comply with this license. So I got in a big tiff with that guy. And it was funny because the Chinese company would give you the software, the company who made the camera, but the downstream providers didn't have access to it, which was really awkward. But if I would have emailed the guy and said, hey, I'd like a copy of the CD and he didn't give it to me, technically anyone at BusyBox who is actually licensed under what's known as the SFLC, which is one of the open source enforcement wings, they're actually known for going after people who violate BusyBox licenses. So you can refer it to the SFLC and they'll say, hey, we have rights under the BusyBox license. You need to provide the CD to XYZ, and they can drag them to court if they need to. But they don't usually. They usually settle it out. I think they're a little soft-handed. So did you guys know you have to provide a written offer? If you distribute, like if you use the GPL v2 for a piece of software and you go redistribute it, I've made my own Linux variant. I'm going to distribute it. You have to give to everyone for 3 years afterwards. You have to be able to provide a physical copy and must accompany the distribution. Anybody do that? No, I didn't think so. I don't think anybody does. So if you have so this is my favorite, the one I talked about that disappeared in the GPL v3. If you violate the agreement, you lose your license and it's not redeemable by correcting the violations. AKA, since if I email and you're like, hey, did you provide that written offer? No. Well, now you actually don't have a license to use anybody's code under the GPL v2.
If you got permission of all of the authors, though, they could do so, right?
As long as you have all of those bundles back together, you have the full copyright, and that power, you can do anything. You can take it out of the GPL v2, which happens all the time, right? People close source previous open source software and say, hey, this is now the community source version. We have our own special enterprise version that we charge a bunch for.
So I was working on an open source project, and they switched licenses, and they had to get
everyone's permission.
Permission from everyone. What would or could have happened if they just couldn't get a hold of someone? Oh, sorry. So I was working on an open source project, and they had thousands of developers and committers on this project. And they decided to switch licenses, and they ended up, they sent a whole bunch of emails to all the developers and authors and everyone that they had to commit to get permission to do the license switch, because it was actually going from a license written in Swedish to one of the languages written in
English.
Yeah, that one. I nearly said American, then I thought better of it. So the question is if they couldn't get a hold of someone, or, do they have to have permission from every single person? Would they have to rip those people's changes? What options would they have if they couldn't, for example, get a hold of someone that they hadn't seen in, say, 8 years?
So the question was, if you've got a piece of software that has a bunch of community developers and you're trying to switch licenses, what happens if you can't get permission from everyone? Well, any code that person they couldn't reach that was committed couldn't be used. Or if it was used, it would technically be a copyright violation until the statute of limitations are in, where it would still be a violation, but it just wouldn't be enforceable. So options they've got are to not use that code or any derivatives afterwards. So there's what's known as a derivative work, right? So Don Quixote, for example, obviously out of copyright, but it was written in Spanish, translated to English. The English version is a derivative right. So the person who wrote the original has rights to the translation. And the same in code, for example, if I write a library and then you branch it or you fork it and then you make some modifications, it's a derivative work of my work. So if somebody had gone in and they'd added a method that did X, Y, Z, and then somebody added some extra code to that method, the extra code added would be a derivative work of the original, so you couldn't use the additions either. Does it make sense? It's kind of running down the chain. You'd have to excise all of that code that they didn't have permissions for. And if they died, it would go to the estate. So it would pass to the estate. And if they had no heirs, it would have gone to a sheet, which means you'd have to go get permission from whatever country or state that had inherited the rights by default. Isn't that fun? That's why we have contribution agreements anymore. Most projects that have any ideas of commercial application get contributor agreements right off the bat, which is actually, I discussed this a long time ago with a person who's not here, unfortunately, a guy who used to attend these cons named Al. And we used to go into long lengths about how the open source world just kind of leaves people at their own peril when developing. Because one of the dumb mistakes I made when writing, Azurius, it was funny. I remember this conversation specifically. It was a French guy and I. We co-founded the product, and I call it Azurius, by the way. Most people call it Azurius, which is probably the pronunciation, but I wrote it, so I get to call it whatever the fuck I want. So Azurius, as it were. I remember we were going to post it up on SourceForge, and it was like, hey, should we use the BSD or GPL v2? And I was like, oh, let's do GPL v2 in case some corporation takes it. And then it ended up years later that they founded a corporation, and we got in some tiffs, and it was kind of funny. I was like, all right, pick that one, all right. Like, just by dumb circumstance. Like, it worked out okay. And, it worked out all right in the long run, and it's still open source to this day, which is great for me. Like, that's what I care about. And I don't care if they run a company on it. That's perfectly fine. Like, that's part of the GPL v2. You can sell GPL software. Like, it's perfectly fine to sell a copy of Linux. You, however, must provide the source code if somebody wants it. But it's interesting. So back to that whole point of it's advisable now that before you launch a project on like GitHub or whatnot, you come up with a contribution agreement, and any developer that wants to contribute code on a pull request or whatnot, you have them provide a contribution agreement, which essentially says, you grant me all rights to control this. You don't have your rights anymore. Like, you've given them to me. And that way, if you ever decide like, hey, I want to change this, I put in 500,000 hours of time on this, I'd like to make some money finally, you can change it without having to get rights from said person. Because otherwise you can get in a big tangled mess of like, oh, he provided 3 lines of code, but yeah, those 3 lines of code have now spawned off, several modules, and now I've got umpteen billion issues, and anything can be litigated. Like, someone can just sue you and drag you into court for years.
So how big does a contribution have to be to require a contributor's agreement?
So any contribution that would qualify for copyright, which technically and legally is defined as, quote, a modicum of creativity.
And fix a bug.
Yeah, but easily fix a bug. I mean, if it provided a modicum of creativity. Someone could add a haiku to your software and you're fucked.
Everyone who submits code to Mozilla must have a contributor.
Yeah. Oh, he was stated that everyone at Mozilla has to have a contributor agreement. As most big corporate, like if you see any large corporate, open source projects, they all have them now. And you can tell the ones who like suffered first, they're kind of funny. They've got their community editions and now their enterprise, which requires an agreement, and the community just tries to die off as they poison it slowly.
So in theory, if I created a bot that created push requests or pull requests for every project on GitHub to add a joke to source code, I could screw over a whole bunch of people?
Yeah, of course. I mean, if you license that under the GPL too. Well, hold on. We'll get to that, actually. Hold that thought. There's a better way to do it. Yes. I got 10 minutes.
About 13.
13? Well, let's hurry the fuck up. We're going to skip all these. So case law, does anybody care? Anybody want to know about case? Okay. Jacobson v. Kratzer. Write these down if you want them. Yeah, the main case, this is the one I was talking about, deals with the artistic license, not the GPL v2. This is the whole conditions versus covenants. I only got 13 minutes, so I'm going to skip through this real quick. If you want the citation, it's this. Happy to give it to you afterwards. Otherwise, conditions versus covenants is a really complex, convoluted area. It's been exploited both ways in decisions later on. I've dealt with copyright cases where courts would want to get rid of something and they would just deem it was a covenant, or they would deem it a condition and say, oh, it's not important, when it clearly was a covenant. So covenants are dealt with right here. This is the main point. Copyrights, conditions are breaches of copyright. So if you break a condition, you have breached the copyright. Now I can sue you under copyright law. If it was deemed a covenant, it's a breach of contract, and I must sue you under breach of contract, which is it's the damages calculations. So copyright violations, for example, have very stringent penalties. You don't have to require much, and if it was copyrighted before the violation or within 90 days after publication, I can sue you for your attorney's fees, which usually is actually the bigger threat than the actual statutory fines. Breach of contract, on the flip side, is, well, sure, you stole my code, but you included a haiku that might be worth 5 cents of creativity. That's all I'm going to get. Because if I would have written a contract with you, and courts can go into this whole hypothetical contract negotiation, your haiku is only worth 5 cents to the world, or maybe a royalty. That's in patents. It's fun. But that's the main thing. So you want, if you're writing software, you want to have conditions, not covenants, is the main point here. And Jacobson said, under the artistic license, it's open source licenses are enforceable under copyright law because they are covenants, which means that minor breaches are actionable. So if you do not comply with every covenant to the T, I can sue you for copyright violation because you didn't comply with my license, and now I can ding you for statutory fees in excess of, or up to, $150,000 per violation of copyright, per copyright. So if you had 15 copyrights filed, multiply that times 150 for willful infringement, or 30,000 on the lower line, and plus attorney's fees. Huzzah! I didn't include it, but one thing I've always wanted to do is make the $1 billion lawsuit, like just bundle a bunch of fucking copyrights with copyright notices into something, and then, post it with notices, and then sue somebody for $150,000 per violation times X number, and just be like, you owe me $1 billion, statutory. And on the low end, be like 30 grand per pop. Be pretty funny. Copyrights, awesome. So planetary motion versus Texplosion, love this one, used this one in a case, caused a lot of trouble in that one, it was really funny, because the opposing counsel raised the exact argument that this says is not valid. Essentially, trademark dispute, this is what the base of the case was, releasing source under an open source license constitutes use in commerce, which is a requirement for a trademark. To get a trademark, you must use something in commerce. And the argument was, open source, you're not selling anything, so it's not commerce. And the court said, no, you've distributed it into the open market, that's commerce, you own the trademark. And trademarks are, so copyrights, you don't actually have to file to own a copyright. I didn't cover that, but if you create something, I doodle on a fucking napkin, I have a copyright on the napkin. Don't touch my fucking napkin. Don't take a photo of it, it's mine. Like, I own that. Like, it's mine. It's my ball.
How do you prove that?
Because I doodled it. Like, and you could fight it in court. I mean, that could be your argument. Like, no, I doodled that motherfucker. And the court will be like, don't curse. And that's really what would happen, like contempt. But realistically, that's actually a lot of fights that come up is like, no, he didn't create it, I created it. Well, someone created it, and if you didn't create it, you still violated someone's copyright, so we can play that game too. But it gets really nasty and messy. But so that's actually in the US, it used to be you had to file there had to be a registration before release. You had to include the copyright notice. We had very stringent rules on that, which is where there's actually fights why they say Mickey Mouse is in the public domain because Walt Disney messed up the copyright notice on the original Steamboat Willie. Pretty cool stuff if you've never read about it. Good, I love that area. Anyway, it's now been flipped to comply with the world under, I think it was the Berne Convention, that it is, as soon as it's created, the copyright is vested in you, like you own that copyright. Same under trademarks. As soon as you release something that's trademarkable into commerce, you actually have a common law trademark. The difference is you can't sue in court until you have the physical document. So I can go and get a copyright filed, and now I can bring a suit against you. Trademarks are the same thing. I can't sue you until I go get a physical trademark issued, even though I own the common law one. I believe that's correct. Don't hold me to that, actually. You might be able to bring a common law trademark suit, but I'm not sure. It depends on jurisdiction, maybe. I'm not sure I think the Lanham Act did override all of that. Anyway, doesn't matter. So this just basically says if you release open source software, you can't have a trademark. Wallace versus IBM, this is one of the later ones. And there were some later fights with this that I'm not sure what the updates are, to be honest. But my favorite quote from this was, the GPL and open source software have nothing to fear from antitrust laws. They raised an argument that the GPL is kind of like just a cohort of antitrust conspiracy, like people were, improperly forming in violation of whatever I can't remember the name of the act. And the court was just like, yeah, that's bunk. Like, these people are just helping the world. Pretty cool. I thought it was a well thought out decision. So this is what I really want to talk about, and I don't have much time, so hopefully I can catch you all some afterwards. But this is the point you were getting to earlier about, trolling everyone with pull requests. Who uses, who remembers this? Anyone know what that means? Does anyone remember this day? It was about May, I think. Company called Kik got a trademark dispute with someone named Azure. I don't even know how to pronounce that. You know Swedish or whatever that is, right?
He pulled the code, and that caused a lot of other people's stuff to break because they were automatically pulling it without vetting it.
NPM allowed you to unpublish repositories. He had one called LeftPad. LeftPad was removed. It was used by all kinds of shit in the Node.js world. So when the dependencies tried to build, they exploded on his library missing. What? So that's just covered all that. He pulled 250 repos called all kinds of shit. So it was like the day the internet broke. I always refer to the day JavaScript broke. But what if instead of that, he did this? So what happens? In NPM, you can define packages, and you can do it in most dependency systems anymore, like this, star, just pull any version, or greater than version, so any updates, I'd like to pull those, security updates, or just leave it blank and it defaults to star, or there's several other variants such as, star and whatnot. So what happens if you change the license and then someone repulls that distribution and then redistributes it? So it was BSD previously, now I've changed the license, and now you've grabbed my GPL v1 software and distributed it. Theories?
Congratulations, you're now in violation.
Yeah, now if you distribute it and didn't distribute the source, I own your ass. Theoretically. Now there's some defenses you could say, like I was tricked into it. No, of course you didn't. That could be that could be viable, arguably. If so, for example, on your instructions, you said to include this library, put star or put plus sign to encourage someone to adopt the whatever. But if you put that and then said, this could result in issues with licenses later on, never happened. But I always thought that was the perfect. I remember when that happened with the Azure guy, and I was just like, oh man, you had the perfect hook. It was the thought experiment I always wanted to see happen, and it just failed miserably, sadly, because instead of it, he just unpublished it. And I remember I got started on that track because I pulled his license. I was like, what's his license? Because if he didn't include one, a lot of people on NPM don't include a license. If they do not include a license, they own the copyright. And if you've taken that, you technically don't have permission. It's not under BSD, it's not under MIT. You just copied his source, and that's not okay. So NPM and all the other dependency places should be really careful about including things that don't have an explicit license, because explicit license just means copyright, vested in said person. Evan?
What if you, in some instances, you have a lot of code now that goes out, when it deploys, it is downloading source or doing stuff.
That's this.
So, even in that instance.
Auto-bound, you distributed it, you agree to the license.
Okay, so
Or your agent did, aka your build system.
Okay, even if they're the ones downloading it.
It's your problem. So who's seen this published before on some kind of repository? I got 4 minutes, so we'll get it there. You seen this? Yeah. So what happens if you take over said repository and then, just change the license? Oh, I'd love to take over that. Oh, I'm happy to maintain it. Whoop, GPL v1. I love it. Anyone does it, let me know. I don't have a Twitter account, but if I did, tweet me.
That brings up a question, though. In the reverse, what if I were, obviously there are cases where it's they did this on purpose, so it was malicious intent type of stuff, back towards, by changing or taking some action, that the sole intent was malicious, therefore.
It's my copyright. I can do whatever I want.
Well, I understand the base.
I wrote this book to piss you off.
Yeah,
Not the first time it's happened.
people that have successfully been able to argue that and not comment.
You could argue it's what's known as a permissive license. So for example, there have been people who have created copyright specifically to try to troll someone into violating it, and that's what, yeah. And I guarantee you that would be the argument made. I don't have to give you my source. I get a permissive license, which it could be done, but a license change is not all too common. It's actually your fault for including future versions. So I didn't tell you, if I told you, hey, to define this, add the plus sign, it's the only way to do it, then you could argue it. But otherwise,
His repo,
was public.
yeah, it was public, and
I have a right to change it if I own the copyrights. For example, I could give a book out for free and then decide I want to sell it.
so yeah, but then somebody could release a previous version, and you wouldn't be as long as
Correct.
Okay.
But that's perfectly fine.
Go back.
No, you can't retroactively go back and change it. So the GPL, if I change it later, those GPL versions are still GPL forevermore. But if you used my future one or the AGPL v1, you need to agree to those licenses or don't use it. And the argument in court is always, you didn't have to use it. You don't have to pick the new one.
Quickest question ever. So if somebody doesn't actually include any kind of license on a piece of software, then they have copyright and there's absolutely no rights, etc., because they own it wholly. If they upload it to a site, for example, like GitHub, where one of the conditions of hosting is that have an open source license, does that provide any kind of leverage, or do you think that's just a case of I'm sorry?
You could argue it was a permissive license, but technically, I would, if I was on the offensive side of that, I would say, well, yeah, GitHub requires that, but GitHub posted it. I still own the copyright. You know, just because GitHub says you need to have it, that's a condition, that's a breach of contract with GitHub. They can sue me for not complying it. You still stole my copyright. That's my personal argument. So this is what I really want to get to, and I've got like 10 seconds, I guess. So mafia style. Who knows the MPAA and the RIAA? Super aggressive trade organizations. I've had this thought in my head forever about what if we applied that to open source. So issues with open source, you got enforcement is weak and largely ignored. There's just not enough resources. So you got the SFLC, the FSF, nobody donates, like it's minor. Everybody gives money to the EFF, who's not an open source group. They're a like digital rights, whatever. They're actually, I've been in cases against people on their boards, for example, that are fighting against what I think is anti-open source, or they're fighting against open source issues, which I just find odd. But there are a few groups, mildly aggressive, SFLC, for example. Standing can be difficult. So if you haven't actually contributed code to a piece of software, you don't have standing to sue for a license violation. So you can't just be like, I'd like a copy of this software. I'm an outside user. The court will say, well, you don't have a copyright. You don't have any skin in the game. You can't sue. You have to find someone who wrote part of that software to sue. That's a problem, right? So most of the people in the open source world can't actually sue for enforcement, or people using open source can't sue. It has to be the people who created it. So you always see the things about the people suing for the Linux kernel. That's someone who's contributed. That's why it's always a contributor. And there's a lack of resources, like I just said. So what if you created the OSAA, the Open Source Association of Antarctica? I don't give a shit. Something I've been mulling for a good decade, like I said. But what if, like I said, I want feedback on this. So what if you remove infringement, and the infighting? So for example, you said people are changing the license. A lot of times what happens is a product goes from open source, somebody decides, oh, I'd like to sell this. There's a shit ton of fighting. One person says, I don't want to deal with that. Or it goes corporate and somebody's like, I'm completely opposed to that. And there's this huge blow up later on in open source projects. Barriers to standing, like I said, the barriers to legal support. So for example, if you want to become an Apache project, you have to create other licenses. You have to go through this whole rigmarole of applying, crowdsourcing the defense to get resources, and then run it for profit so you're not some mamby-pamby, let's all be nice. Because you don't have to be nice. You're trying to help the world anyway. So easy to opt into protection. So for example, you can copyright an image, you can copyright an ASCII logo, and you could bind that to the OSAA. The OSAA would own the copyright. That can be placed into any piece of software easily by copying and pasting it. At that point, you have now taken the OSAA's license under the GPL v2 or whatever license that's compliant with yours. You've placed it in your software. The OSAA at that point would have standing to sue on your behalf if somebody violated your copyright. You could now take that and then crowdsource it on the OSA's website, because it's easy enough to run through GitHub and say, find me everything, search for whatever magic keyword you've included in that license. You can pull up all the projects, reverse, right? I can load all the GitHub projects that have that, and I can say, hey, here's a list of projects on the OSAA. If somebody finds a violation, they can post it to the OSAA and say, hey, we should do something about this. Members who are, followers, members of the OSAA can then vote and say, hey, we should do something about that. Filing fees aren't a lot. Copyright cases are relatively easy compared to a lot of other cases to prove, like, here's my code, I've clearly written it, here's where it's been copied, it's not compliant. Suit is brought, enforcement is done, negotiations can be had. And I really want thoughts on that. That's what I want this whole talk for, which I probably have no time left. But we'll do that after if anyone wants to.
Or give them a hashtag to tweet.
Yeah. So there you go. Any guys have any questions? Sorry, we ran over a little bit there. But how much time do I have? I'm out. So I'll catch anybody outside if they want to talk about something. If not, thank you so much.